Assalamualaikum and good day. My topic is concept of monism and dualism in the context of international law. At the end of this lesson, I hope I have managed to briefly explain in the context of a state and international law or international agreements the difference when a state practices concept of monism as opposed to a state who practices dualism concepts. These are the whole structure of the chapter. The slides before this has been talking about what is international law, differences between international law and national law, differences between public and private international law, sources of international law, and last but not least, the last chapter of this topic is concept of theory of monism and dualism in relation to international law. Now, let's look at the first theory or concept, which is the concept of dualism. This concept is based on dualist theory or theory. In dualism, international law and national law are two separate legal systems which exist independently. International law and national law in a dualist state remain separate from each other until the state has mandate to incorporate the international law into its national legislation. In a democratic country, the mandate must be given by a legislative body who are the representatives of the people, chosen to make law for the people. This means there must be 3 steps before an international law can be applicable. For example, in Malaysia, the first step is signing of the international agreement by a representative of Malaysian government or executive body. For example, at United Nations level. Second step is to convince the Malaysian Parliament to accept and agree with the international agreement so that the Malaysian representative can go back to UN and ratify the international agreement. The third step is to adopt and adapt provisions of the international law into national legislation or law. For example, in 1995, Malaysia acceded to United Nations Conventions on the Rights of the Child 1989 UNCRC by signing and ratifying the UNCRC. After that, Malaysian government, that is specifically Malaysian Parliament, adopted and adapted UNCRC into Malaysian Child Act 2001. In a Malaysian court, the national law like Child Act that is binding on the court. This means the court has to follow the provisions in the in the child law. The international law, for example, UNCRC, can be used for arguments, but it will only be a persuasive law. Therefore, in a dualist country, there is a possibility that the two systems, which is international law and national law, can come into conflict when they are dealing with the same subject matter. As such, if the matter is brought to a national court, for example, Malaysian court, the court will decide according to a dualist concept, which means the court will follow the national legislation, and whatever that is embedded in the national legislation, that is applicable. This has been applied and can be seen in the case of Regional Center for Arbitration against Oi Beng Chu and another, number 2, 1999, volume 7, CLJ, page 443. In this case, the court acknowledged the validity of a subsidiary legislation, which is KLRCA Regulations 1996, made pursuant to an act, which is International Organizations, Privileges and Immunities Act 1992. The act was made to implement the Convention on the Privileges and Immunities of the United Nations, 1946, which has been acceded by Malaysia, which means the Convention on the Privileges and Immunities of the United Nations level is the international law, and it has been acceded and adopted and adapted into a national law, which is the KLRCA Regulations, 1996. Another example is the Diplomatic Privileges Vienna Conventions Act 1996, amended in 1999 to give legal effect to Vienna Convention on Diplomatic Relations 1961. Again, you can see how a dualist concept is applicable, whereby the international law, Vienna Convention on Diplomatic Relations 1961, has been adopted and adapted into a national act, which is Diplomatic Privileges Vienna Conventions Act 1996. Slide 7 is a graphic example of a dualist concept which illustrates the adoption and adaptation of international law into Malaysian national law. Now, let's look at the second concept, which is the concept of monism. Monist concept in relation to international law views that international law and national law as a single order. This means that when a government of a country signed and ratified an international agreement at the international level, it will automatically be applicable in the country nationally. So once acceded, the international agreement will automatically be applicable in the national law. Should there be any conflict between the international law and national law in that country, the international law will prevail or supersede the national law. In this monist theory of law, international law is deemed to be more superior than the national law. Example of a country using monist concept is Japan. This means that whatever international law that Japan signed and ratified will be automatically applicable in Japan. As such, there are only two steps applicable in a monist country. First is the government representative or executive body signed the international agreement. And second, if the Japan's legislative body agrees to accede to the international agreement, they will ratify the agreement and it will take force as per the terms of the international agreement. Other countries who apply monism theory as well are Netherlands, France, Switzerland, and etc. Last but not least is a mind map to sum up this lesson. Enjoy! Thank you for watching and listening to the end of the slides.